So at this point, both sides will be giving our closing argument, basically a summation of everything you've heard, just so you can jot down things, take notes if you feel comfortable. So you all heard all of the evidence in this case, and the distinction between a civil case and a criminal case are different. And what that means is, in a civil case, our proof, what has to be in the box, is greater than 50%. Touch more than 50%, maybe a featherweight more than 50%. 51%. It's not 100%. The standard is a little bit more than 50%. In this case, you've heard lots and lots of testimony. We've had the plaintiff who's testified. We've had the plaintiff's mother who's testified. We've had the plaintiff's grandmother who's testified. Those three witnesses explained their recollection about the scar. There was testimony that the scar, or the cut, came from this incident. That's a very, very important fact. There's really nothing to contradict that. If anything, our expert witness, Dr. Mulliken, you remember he came to court. He's a very well-respected doctor that specializes in plastic surgery. And his testimony was that, in his opinion, as an expert, that when the way that this scar, the way that this cut happened was from fingernails. And that there were three different scrapes, three different scratches. And that the middle one was the deepest one. And that's really the one that he worked on. Now, the issue in this case, well, before I go to that, is the photograph that you saw, okay, which is in evidence. There's a photograph of the scar, which is a 2-centimeter scar. The photograph, because of the skin color, it does not show well in photos. The cut that was on the face does not show up as well. So you may have to really look at it deeper than just had it been someone else. The other thing that I wanted to highlight is I really just don't understand. The defendant came here, used all of this foul language. This is a court of law. You cannot speak this way in a court. I have never seen this before. And for her to use all of those words, F word, B word, all these different words, it's a disrespect to us. It's a disrespect to the judge. It's disrespect to this courthouse. You cannot come to court and say these kind of words. It's just disrespectful. And just because Miss Ellis, just because Miss, also known as Cardi B, is a celebrity, doesn't mean that she could just say and do whatever she wants and attack people. Okay? If you recall, just to give you a little bit of background about Miss Ellis. When she was 19 years old, she moved out of her house. She went to college. She's a college graduate. She has a bachelor's. She went on to become a security guard for 4 years, from 2014 to 2018. She did whatever she needed to do to become a licensed security guard. And she did that job. And when this incident happened in 2018, that was cut off. She lost her future in security work, in something further, whether it's FBI, police, attorney, whatever she wanted to do. This incident cut it off. No more. Because of the trauma that she sustained. And I get it. There were doctors who gave their opinions. For example, the defense brought Dr. Rosenberg. Nice guy, gentleman. He complimented me. Maybe he's doing that because he's a psychiatrist and he knows what to say to twist everything. But the point is, he got $40,000 to come here and basically tell us that the plaintiff didn't suffer any emotional injury. That's not the facts. The facts are Imani Ellis was working as security guard. There was a change. Okay, it's very, very traumatic to be assaulted and battered. I can only imagine the embarrassment, the emotions, the pain that Miss Imani Ellis suffered. Now, in this case, there was overwhelming testimony that Miss Ellis was working as a security guard at the time of the incident. There's no question. She was in full uniform. She had a badge on. Even the defendant admitted, yes, I understood that this person was a security guard. And there has to be some level of respect. These are not doormen or doorwomen. The defendant, when she came to the building, instead of listening to the plaintiff, to listening to her commands, you got to do this, you got to do that, please leave the building, different commands were given to her, which none were followed. They were all ignored. Instead, people that I'm here. These were the thoughts testified to those. Give us that opportunity. Each has plans to do other if to the lost her future in security work, in something further, whether it's FBI, police, attorney, whatever she wanted to do. This incident cut it off. No more. Because of the trauma that she sustained. And I get it. There were doctors who gave their opinions. For example, the defense brought Dr. Rosenberg. Nice guy, gentleman. He complimented me. Maybe he's doing that because he's a psychiatrist and he knows what to say to twist everything. But the point is, he got $40,000 to come here and basically tell us that the plaintiff didn't suffer any emotional injury. That's not the facts. The facts are, Imani Ellis was working as security guard. There was a change. Okay, it's very, very traumatic to be assaulted and battered. I can only imagine the embarrassment, the emotions, the pain that Miss Imani Ellis suffered. Now, in this case, there was overwhelming testimony that Miss Ellis was working as a security guard at the time of the incident. There's no question. She was in full uniform. She had a badge on. Even the defendant admitted, yes, I understood that this person was a security guard. And there has to be some level of respect. These are not doormen or doorwomen. The defendant, when she came to the building, instead of listening to the plaintiff, to listening to her commands, you got to do this, you got to do that, please leave the building, different commands were given to her, which none were followed. They were all ignored. Instead, the defendant thought that, well, Miss Ellis was on her phone. She was telling people that I'm here. These were the thoughts that were going through her head at the time, and she's testified to those. However, that's not the case. Miss Ellis testified that she's never had a fight before. She's never done anything to harm anybody. She's never had any fight with anybody. And her mother and her grandmother also testified. She's a model citizen. She's a hardworking person, and she simply, her whole goal of doing this to be here and sit here and go through this is so she could move on with her life. Sometimes people have to be heard. So by you all being here and hearing everything that's gone on, you have given her a sense of closure where she can move on and go on to the next step and the next phase. She's only 32 years old and she has plans. She has plans to do other things in her life. So we're very thankful that you gave us that opportunity. Each and every one of you, we're very thankful. The other thing I wanted to mention is the phone. It would be impossible for someone to be videotaping someone and be on a phone call at the same time. I tried it myself. And the error message that you would get if you tried it is, recording video is not available while on the call. So it couldn't be. The two of them couldn't be done at the same time. Miss Ellis told Cardi B multiple times, I am not recording you. I am not telling anybody that you are here. I'm simply doing my job. And instead of maybe agreeing or investigating further, Miss Almanzar, Cardi B, got angry and started yelling and cursing and spitting on Miss Ellis and calling her different words, using the N-word to disrespect her, calling her the B-word, calling her fat, anything to try to trigger her and make her upset and embarrass her. Sometimes words are more painful than the physical. And to add insult to injury, she then cut her face and caused a scar on her face. And what happened then? Miss Ellis had to go see different doctors. The court did read about Dr. Scher, a sentence that basically that it's undisputed Dr. Scher died. And Miss Ellis basically testified that initially, a couple months after the incident, she saw Dr. McKenzie, a psychologist, through her workers' compensation. She was given that. She got 7 visits with that doctor. During that time, she also saw Dr. Scher, who was another plastic surgeon. Unfortunately, we don't have him here. We don't have his records because he passed away. So that's why that was read to you in open court, so that it's some sense of fairness. Why there's no records from Dr. Scher.
Objection, Your Honor. Assistant.
Then we learned throughout the case that when Cardi B came to the building, she caused a disturbance. She caused a disturbance. She was yelling and screaming at the top of her lungs, going crazy, yelling and screaming, to the point where 2 other witnesses, Miss Malcolm, which was the secretary of the doctor, and Dr. David Finke, was so loud that those 2 people came out after about 40 to 50 seconds. Now, the issue with that is those 2 witnesses didn't see the 4 things that happened before that, which happened in the 40 to 50 seconds before. So yes, they're witnesses, but they're not witnesses to that first part, that first segment, which would include taking a swing at Miss Ellis, spitting on Miss Ellis, calling her the N-word, and ultimately cutting her face. None of that was seen by those 2 witnesses. So yeah, they're witnesses, but they're witnesses to the aftermath. They're witnesses to what happened afterwards. They're not eyewitnesses. They don't know what really happened. And when they arrived, Miss Ellis was so upset. Can you imagine all those 4 things happening, being disrespected, embarrassed, who knows what else happened? All of that was done to her, and she still was able to contain herself to a certain degree. But yeah, sure, I mean, naturally, she was angry, she was emotional. So when these 2 witnesses come out of their offices, they can only see an angry person. They didn't see what led up to that, and they had assumed that it's her fault, maybe, or that she did something wrong. But again, those 2 witnesses didn't really see much. They saw something after the fact. And then you have Miss Malcolm, who decided on her own, this was her choice, to squeeze herself in between the two people. Well, that's a risk that she took. And if she somehow got a cut to her face or a scratch or something, well, we don't know who did that. We really don't know. She didn't even know. Miss Malcolm testified that she did not know who scratched her face. She has no idea. What does that mean? It could be from either one. It could be from the commotion that's going on. These things happen so fast, we have no real idea as to what really happened. Unfortunately, there was no video camera there. There was no other witnesses that actually saw it. So it really comes down to one thing. Do you believe Miss Ellis? Why not? You should. She's a hard-working security guard. She was doing her job with no prior anything.
Objection. Assisting.
At some point during the trial, the defendant showed you Exhibit 232. You all remember this photograph? Exhibit 232, this is a photograph. Now, the issue with this photograph is there's really no way to know the date that this photograph was taken. There's no way to know. We don't know when it was taken.
Objection. Overruled.
There is no proof of when this photograph was taken. It could have been taken at any time,
Objection.
before or after the incident.
Overruled.
It could have been, and in this case, the defendant testified that this photograph was taken on the date of the incident.
Objection, Your Honor. Overruled.
That was her testimony. But where's the proof? Do you really believe that a celebrity can't prove when this photograph was taken? She testified that this photograph was taken at the All-Star, NBA All-Star game. There's no proof of that anywhere? That's just false. There is proof of when this photograph was taken. It just wasn't given to us. It wasn't provided to us. So we can't rely on this photograph because there's no date on this photograph. The next thing that Miss Ellis did is she made an incident report. 2 days after the incident, Miss Ellis wrote an email to her boss and followed what she was supposed to do to explain all of the details of what happened to her. And she did follow company policy and did what they asked her to do. She called her supervisor, made an incident report, and did everything possible to document all of the different things that happened to her on that date of February 24th, 2018. The other important issue is Cardi B testified that she came to the building, at least downstairs of the building. She had a security guard with her, Mr. Newton. Mr. Newton, that's her security guard. He didn't testify in this case. Why not? Where is he? Disappeared? Miss Ellis testified that when she saw this security guard downstairs in the lobby, and she met with him there, Mr. Newton apologized
Objection, Your Honor.
for what happened.
Overruled.
Mr. Newton should have testified in this case and could have testified in this case, but he didn't. And there is a jury instruction, KC Jury Instruction 203, which deals with a party having power to produce better evidence. The jury instruction states, you may consider the ability of each party to provide evidence. If a party provided weaker evidence when it could have provided stronger evidence, you may distrust the weaker evidence. That's what the law is. So, where's Mr. Newton? I don't know. He was on the witness list. He should have came here and testified.
Assisting.
Another important fact is, if a witness is not credible on one point, you can disregard their entire testimony. When you go back into the jury room, you will have all of these different jury instructions. And each jury instruction will be there for you where you can read and understand what the law is and how it applies to this case. And as I told you before, testimony is evidence, and you can rely on testimony alone to come up with your verdict. KC 107 states, do not make any decision simply because there were more witnesses on one side than on the other side. If you believe it to be true, the testimony of a single witness is enough to prove a fact. So in this case, you've heard from different witnesses. Just because one side may have more witnesses or less, that's not how it works. One witness is sufficient to prove a fact. You initially heard that Ms. Ellis saw a Dr. Nicole McKenzie. Dr. McKenzie testified. She's a psychologist. She treated the patient in her office, between her and other providers in her office, a total of 7 visits for a period of 8 months. Ms. Ellis did seek psychological care and received it. She also, as I said, went to Dr. Scher. Dr. Scher advised her that he could not do the plastic surgery for a couple reasons. One is, you have to wait at least a year. You have to wait at least 1 year, 1 to 2 years, to determine if the scar will become a keloid. If the cut will become a keloid, if it will become a scar. Sometimes it may go away on its own. In this case, it did not go away. After that time period, if we all remember that in April of 2020, the pandemic occurred. We had this pandemic outbreak where everything was closed. You can't just go and have elective surgery. So the case was delayed. The medical treatment was delayed. That's why Ms. Ellis waited. Another factor is affordability. She had to find a doctor. We had to help her find a doctor that was willing to work on a lien basis. Dr. Mulliken testified that he would agree that he treated her on a lien basis. What that means is she still owes the money. However, in a court case, what happens is the doctor will agree to treat the patient and delay payment. They delay getting paid. That's what Dr. Mulliken did. Dr. Mulliken testified that he fully examined Ms. Ellis. He then decided, with his expertise as a board-certified plastic surgeon, that it would be beneficial for Ms. Ellis to have plastic surgery and have this done in a surgery center. 2 different surgeries were done over a period of 3 to 4 months so that Ms. Ellis could, there were 2 issues. She had hypersensitivity, a little bit of hypersensitivity, and also, as a woman, she doesn't want to have a scar to her face. And all the time, every day, waking up in the morning, looking in the mirror, remembering the event, it reminded her. It does remind.
Assisting.
Now, the defendant had the ability to hire their own plastic surgeon and have their own expert witness.
I'm sorry. Overruled.
And in this case, the defendant decided not to hire one. So what does that mean? What that means is you really got to take what Dr. Mulliken says with a lot of importance, a lot of truth. There is no other doctor from the defense side. They could have spent money and hired somebody and had them testify here and tell us, yeah, Dr. Mulliken's work is no good, or she could have done something different, but we don't have that here. You have one doctor on the plaintiff's side basically explaining all of his expert opinions. And he's a board-certified plastic surgeon for 30 years. He's affiliated with UCLA, and even testified that he, in his career currently, does teach medical students at UCLA to help them in their careers of becoming plastic surgeons themselves. Now, when you go back into the jury room, you'll see Dr. Mulliken's records and bills that are part of this case. They've been admitted into evidence, and you will see his medical report, and you will see his medical bills. Those are admitted into evidence. You'll have that in the jury room, so you can see it for yourselves. And if you remember, even Dr. Rosenberg had testified that he has seen Dr. Mulliken in other cases. He's been an expert in other cases working alongside Dr. Mulliken. And this is a very well-respected doctor. He went to Yale Medical School. Even Dr. Rosenberg testified that he had impressive credentials. He acknowledged that fact. And the other thing that I wanted to discuss would be the fingernails. The Cardi B testified that most of the time she would have long fingernails of 3 inches. That's her style. That's what she did. And in this case, not only did she have these long, sharp fingernails, she also had rhinestones. If you remember Dr. Finke, he was a fingernail, that was his thing. And he basically said he remembers the rhinestones, that they were protruding.
Objection, Your Honor.
They were raised.
Sustained.
When Cardi B testified, she acknowledged that she refused to listen to Miss Ellis, who was the security guard on duty at the time. There was also testimony by Cardi B that the two of them were chest to chest, touching. This was a touching that Miss Ellis didn't want. Miss Ellis didn't want to be connected to Cardi B physically, but Cardi B made that happen, and that's an unlawful touching. That alone, aside from the rest, that alone, Cardi B admitted to that fact. She said, that is what I did. I was chest to chest with Miss Ellis. Cardi B even testified that she was yelling and screaming so much that she acknowledged that it was possible that her spit went on to Miss Ellis.
Objection, Your Honor.
That was in the testimony.
Overruled.
When Miss Ellis told Cardi B to leave the building, she should have left the building. Miss Ellis was hired by the owner of the building to keep the building secure and safe for tenants and other patients and visitors. Cardi B refused to listen to the security guard who was working there. At some point, Cardi B caused such a disturbance that what she was doing was a trespassing. You cannot be on the property when the owner or an extension of the owner tells you you have to leave. You have to leave. Miss Ellis's mother, Leanne Schmidt, testified. She testified that Miss Ellis obtained the scar to her left cheek as a result of this incident.
Objection, Your Honor.
Miss Ellis's mother testified that she recalled seeing the scar after this incident. Miss Ellis's mother testified that she saw changes in her daughter after this incident. Same with Miss Ellis's grandmother, Diane Schmidt. She also testified that she recalled seeing the scar after this incident and that she noticed a marked difference in Miss Ellis after the incident. That's her granddaughter. The defense put on a Dr. Rosenberg, who was a hired gun, received $40,000 for this case and makes millions of dollars in this type of work. He criticized the Kaiser Hospital for not writing down that Miss Ellis had emotional injuries when when Miss Ellis went to Kaiser Permanente for vaginal discharge in 2022. Dr. Rosenberg testified that there was an inconsistency when Miss Ellis went to Kaiser and didn't tell them about her emotional injuries. Why I'm bringing this up is very simple. When someone goes to an orthopedic surgeon, they don't talk about dental injuries. When someone goes to a gynecologist, they don't talk about emotional injuries. What really happens is when someone goes to a psychologist or psychiatrist, they tell them about their emotional injuries. When someone goes to a dentist, they tell them about their broken teeth. When someone goes to an orthopedic surgeon, they tell them about their neck pain, their back pain, their left foot pain, left ankle pain. This idea that every time you go to a doctor, no matter what specialty, you have to cover all these things is not real. It's not real life. Some of the doctors will even say, don't tell me, I don't want to know. I'm not writing it down. Yes, sir. We've all gone to doctors, and we all know when we go to a specialist, we'll focus on why we're there. Miss Ellis went to Kaiser Permanente Hospital for vaginal discharge in 2022 and different things throughout her time there. She didn't go there for emotional injuries. She didn't go to the psychiatric care there. She didn't get any psychological care there. None of that. So for Dr. Rosenberg to sit there and tell us there's inconsistencies because in Kaiser she didn't tell him about the emotional injuries, it just doesn't make sense. I want to talk a little bit more about Miss Malcolm. So I just want to remind you that when Miss Malcolm came out, 40 to 50 seconds had already transpired. She came to the aftermath. I know I've already said that, but I really want to hammer this home, that she is not a witness to what happened before. It's like a car accident. There's two cars, they have an accident. If a third car comes down the road a minute later and hits them, it's completely different. It has nothing to do with it. So that was inserted into this case, in a sense, to muddy the waters, to kind of cloud what really happened. What really happened here in this case is Miss Ellis was working as a security guard. She had to be there. She was working there as a security guard. And Cardi B came along and thought she's above the law. She could do and say whatever she wants and attack Miss Ellis emotionally, physically, and do whatever she wants in a building which is inappropriate. We all know that when we go to a building, you got to be respectful. especially to security guards that are working there. These are not just doormen or doorwomen opening the door for you. You have to follow along with what they say. Next, we heard from Dr. Finke. Want to talk about inconsistencies? There was an inconsistency between Malcolm and Finke. Malcolm said, I don't know how I got this scratch on my forehead. I don't know. Dr. Finke comes out and says that Malcolm told him that Ellis had scratched her face. That's not true. That was never said. So this, if you remember, this is a 7.5-year-old incident, and that's a few thousand days ago. It takes a lot of time has passed, and an incident can be perceived differently by different people. So Miss Malcolm could have perceived it one way, and Dr. Finke could have perceived it one way. But again, same problem with him is when he came, everything had already been done. The whole incident already happened. The injury was already complete. And really this comes down to believing Miss Ellis. She gave you no reason not to. She's been truthful through me and through herself and through her witnesses to give you whatever is there, to provide for you all that she could with the things that she has available to her, so that you could give her the peace of mind, the closure. And yes, she is asking to be compensated for the loss that she sustained. She lost something, and by you compensating her with money damages, you're then evening the playing field. You're giving her what she lost back. So she's not trying to gain something that she's not entitled to. Unfortunately, she was abused, she was harmed, she was assaulted and battered by Cardi B. And Cardi B needs to pay for that and needs to be accountable. We need to hold her accountable. We should not just let her walk away and say, oh, everything you did was okay, and yeah, do it again. Now, in addition to seeing the two plastic surgeons and Dr. McKinsey, Miss Ellis also received another 12 visits of, she testified that she saw a psychologist, Dr. Avila, and other
Objection, Your Honor.
people in his office.
Violation of the court's order.
Move on, Counsel.
The other thing that Cardi B failed to do, or could have done, is she could have filed a cross-complaint.
Objection, Your Honor.
All right. And then I want to go over a little bit about the medical bills. So you don't have to get it exact. It doesn't have to be an exact number. But there was testimony in this case that Miss Ellis had $17,500 in medical bills from Dr. Mulliken, the plastic surgeon, and another $18,000 in psychological care through her work comp and other things.
Objection, Your Honor.
There was also testimony from Dr. Mulliken that he believed Miss Ellis could benefit from one more surgical procedure, another one, to make it better. The cost of that was $15,000.
Objection, Your Honor.
Overruled.
The $15,000 that would be paid for that would, in Dr. Mulliken's expert opinion, it would make the scar better, meaning it would reduce, it would basically what I'm saying is there's still some scar on her face. And if you want to look at it, you're more than welcome. You can have her walk around. You can look at it for yourself. There is still some scar on her face. It's still there. It still bothers her. So that's why I'm asking that not only you give her the $17,500 in her past medical bills for the scar, that you give her another $15,000 for the future scar revision treatment. She didn't deserve this. She didn't deserve to be scratched and cut and spit on and all these things. All of the things that happened to Miss Ellis are they're wrong. And we want to make this wrong right. And how can we do that? Through each one of you. You have the power to make this wrong right and close the books for Miss Ellis so she can move on with her life as much as she possibly could. And yes, the only way to do that right now for today's purposes is to reimburse her for the losses that she sustained. Those are the medical bills, the past, and the future. The other thing that is an important way of compensating Miss Ellis is for her pain and suffering. In every case where there's medical bills and there's medical damages, a component of that is pain and suffering. There is really no way, there's no exact math to that. So for instance, if you said, I want to give her the $17,500, I want to give her the $15,000, and I want to give her another $250,000 for pain and suffering. You are allowed to do that. It is a number that you can come up with. During the 7.5 years that she's been suffering, you may say, I would like to give her $100 a day. For 1 year, that's $36,000. And for 7 years, that comes up to $270,000. We're not looking for millions of dollars like the defendant said. That's not what we're looking for. We're really looking for a simple amount of money that can make her whole, give her something that's fair so she can get some form of compensation, some form of closure, and move on with her life. That is all we're asking you to do. So, when you go into the jury room, you'll be given a verdict form. And the verdict form will basically state, it covers all of the different areas of this case. The first section A is the assault and battery. They are, in a sense, separate because the assault is the swing and the battery is the scratch and the cut to her face. However, it's very clear. Did plaintiff Imani Ellis prove all of the following elements of battery? And then it goes down, it breaks it down. Defendant Belcalis Marlenis Almanzar touched Miss Ellis with the intent to harm or offend Miss Ellis. Miss Ellis did not consent to being touched. Miss Ellis was harmed or offended by Miss Almanzar's conduct. A reasonable person in Miss Ellis's situation would have been offended by the touching. I would say that yes, all four of those have been done here. So when you get to that question, there is going to be on the right side, it's not broken down into 4 parts. It's all as a whole. So if you want to give money damages to Miss Ellis, you would check yes. Okay, and then you go to the next question. Did Miss Ellis prove all of the following elements of assault? And again, it breaks down for you the 5 different parts. Miss Ellis acted with the intent to cause harmful or offensive contact with Miss Ellis. Miss Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner.
Miss Ellis did not consent to Miss Almanzar's conduct. Miss Ellis was harmed, and Miss Almanzar's conduct was a substantial factor in causing Miss Ellis's harm. Again, if you want to give her money damages, you would check yes. That would be page 2, both of those. Then you have question number 3. Did Miss Almanzar prove all of the following elements of self-defense? So the defense is trying to argue that all the things that Miss Almanzar did were in self-defense. There is no testimony of self-defense here. In fact, Miss Almanzar herself, her position was, I didn't touch anybody and nobody touched me. So self-defense, no. You would say no. Then you can go, then question number 4 speaks about the damages that she suffered. Past medical expenses. That's where you would put in an amount of money through the testimony that you heard and through all of the exhibits. You would put an amount of money that you believe Miss Ellis incurred in this incident. So you will have in the jury room exhibit number 4. You'll have exhibit number 4. It's been marked at the bottom right corner. You will have exhibit 4-1 through exhibit 4-6, and then it will skip over and you will go to the bills, which will be 4-13, 4-14, and 4-15. If you combine all of these bills, you will get $16,500. So past medical expenses would be $16,500. That would be what you would write there if you want to give her the cost of all the plastic surgery she had to go through up until now. The future economic loss is the future plastic surgery. Dr. Mulliken stated that Miss Ellis would benefit from a future plastic surgery of $15,000. So you'd write $15,000 in that box. Pain and suffering. Again, there is past pain and suffering and future pain and suffering. The court read a time frame for you of how many more years Miss Ellis will live. And the jury instruction life expectancy, 3932, basically states that Miss Ellis will live for another 50 years. This is an estimate. It's not 100% certain, but it's the best estimate that we have based on all kind of statistics. She has 50 more years to live. So if you feel that she's going to suffer from this point forward, then you can award her money damages for the future. And if you feel that she sustained pain and suffering in the past, then you can award her money for the 7.5-year time period. And again, you'll all have the jury instructions in the back when you go into the jury room. And the jury instruction on pain and suffering covers a whole bunch of different things. Very important. Very important. So I would take a look at that one, because it covers all of the different things. Embarrassment, pain and suffering, disfigurement, all of those. So if you look at 3905, it talks about physical pain, mental suffering, and or emotional distress. And it basically says that there's no fixed standard for deciding the amount of these damages. This is a number that you will come up with. It won't be based on chance or a flip of a coin, but it will be a number that you come up with. If you decide you want to give her $500,000, you can do that. If you want to give her more, you can do that. So for past non-economic loss, you should put a number there. Because if you don't, the award will be thrown out. You got to have at least $1 there. You got to award some kind of pain and suffering. It's required. Now the amount would be up to you. A lot of times, some people say, well, 3 times medical bills, 10 times medical bills. This is an assault and battery. It's just not a simple car accident where it's just, some bumps and bruises. This is a serious, serious injury. Very serious. And Miss Ellis has been suffering for the last 7.5 years. What kind of weight do we put to that? What kind of number do we attach to that? I don't know what number you're going to attach to that. But for purposes of now, for example, you could write $250,000 for the past pain and suffering. This was a violent attack. She was violated. She has a scar to her face now. She's gone through all kinds of medical treatment that she didn't have to go to. So much life was lost from her, time-wise. You can't get it back. All this time that she's lost and feeling embarrassed and all of that. What is the value of life? It's significant. We all went through the pandemic. We all went through the pandemic, and we realized that after the pandemic, the value of life is much greater because we realized what life is really about. Future non-economic loss. Again, that's going to be for the 50 years going forward. You could pick what number you feel. Maybe you feel she's recovered. Maybe you feel she deserves another 10 years. Maybe the whole 50 years. I don't know what it is. But you as individual judges will work together as a team to come up with a number for the future non-economic loss. Then it goes into intentional infliction of emotional distress. Did Miss Ellis prove all the following elements of intentional infliction of emotional distress? Number 1, Miss Almanzar engaged in extreme and outrageous conduct beyond mere insults, threats, indignities, annoyances, hurt feelings, or other trivialities that a reasonable person is expected to endure. Miss Almanzar intended to cause Miss Ellis emotional distress. Miss Ellis suffered severe emotional distress, and Miss Almanzar's extreme and outrageous conduct was a substantial factor in causing Miss Ellis to suffer severe emotional distress. If you believe that Miss Ellis sustains emotional distress, then you would, on number 5, you would say yes. Then number 6, again, it says, did Miss Almanzar prove all of the following elements of the privileged conduct defense? So again, it's similar to a self-defense of this, and it goes through a whole laundry list of different ways and finding excuses why the conduct was okay. So you would put no there if you believe that the conduct caused intentional infliction of emotional distress. Then number 7 has its own damages component. However, we've agreed and conceded to the fact that we don't want you to award damages for the same thing twice. It's not what our goal is. The goal is, if you feel there should be separate damages, aside from the assault and battery, for the emotional distress, then this is where you can give that amount of money. It'll be a separate and apart damage area for you to award more damages. The same breakdown. You can give past medical expenses, obviously, past and future medical expenses. In this, if you're awarded in the first box, then you would say, 0 and 0, because we're not asked double dipping here. That's not our goal. However, pain and suffering. If you want to give separate pain and suffering for the emotional distress, separate pain and suffering for the emotional distress from the past and the future, this is where you could do it. You could say, okay, well, we're going to give 50,000 additional for the past, 50,000 additional for the future, and then we're going to move on to the last part, which is negligence and contributory negligence. And again, this is all from the form that you're all going to see when you go into the jury room. And I'll close with this. Did Miss Ellis prove all of the following elements of negligence? Miss Almanzar was negligent. Miss Almanzar's negligence caused Miss Ellis to suffer physical harm rather than only emotional distress, and Miss Almanzar's negligence was a substantial factor in causing Miss Ellis's harm. So what that means is, for example, was Miss Almanzar, was Cardi B negligent in thinking that the plaintiff was disseminating her privacy to others, photographing her, videotaping her? If you believe that Miss Almanzar, Cardi B, was mistaken, then that would be negligence. She was negligent. She negligently thought that all these things were happening. And then again, it asks for the damages. Same thing. 0 and 0 for the past and future medical expenses if you have given it in the first phase. So there's different areas. Maybe you'll say, well, I don't really believe there was this, but I believe there was that. So anywhere on the form, we would ask that you award Miss Ellis her medical bills of $16,500 for the past and $15,000 for the future, and in different boxes and different areas of this form to award her the pain and suffering that you feel is fair for all the things she went through, the assault, the battery, the emotional distress, all that she should be compensated for. And then there's a box, did Miss Almanzar prove all of the following elements of contributory negligence? Miss Ellis was negligent. Miss Ellis' negligence was a substantial factor in causing her own harm. Well, Cardi B testified that Miss Ellis didn't touch her, didn't do anything. There was no physical contact. That was the testimony of Cardi B. So how can she say that there was contributory negligence? What did the security do wrong? So the answer would be no. And then it goes to number 11. What percentage of responsibility for Miss Ellis's harm do you assign to Miss Almanzar? Let's say 100%, and Miss Ellis, 0. And the final page deals with punitive damages. Did you answer question 4 or 7? And you look back, and if you did, which is the damages, then you put yes. And then it says, did Miss Ellis prove by clear and convincing proof that Miss Almanzar engaged in conduct with malice, oppression, or fraud? And then you would look at the case as a whole and kind of come up with your opinion. Did all of these things combined, did all of this thing that Miss Ellis went through? And remember, it's or, so it's either malice, oppression, or fraud. So if you agree that there was, then you would say yes here. So at this point, I'm going to turn it over to my counterpart. They will obviously contradict everything I will say, I've told you, and then I will have a chance to come back and rebuttal and clean up anything that was said. At this point, I'm basically Miss Ellis's mouthpiece, and I work with her as best I could to convey all of the things that she wants you to know. I worked with her personally to tell you all what she went through, and I did the best that I could with what I have. And we really, no matter what happens, whatever is supposed to happen will happen, because that's what's supposed to happen. And we want to thank you each individually for being here. Each of you as individual judges, we're thanking you very much. Thank you so much for hearing the story as to what Miss Imani Ellis went through, and I'm asking you to award Miss Ellis an amount of money that you think is fair that will make her whole for the losses that she suffered in this case. Thank you very much.